Madam President, Madam Honorary Dean, Mr. Dean, ladies and gentlemen, especially dear students in the room, I'm extremely pleased to be able to contribute to this lecture series on the future of Europe. And of course, you're well aware of the fact that when you speak in such a lecture series as a president of a court, then you have a very particular perspective, because a court is there to react to the cases brought to it. A court never takes the initiative to pick up somewhere in the landscape a legal or another problem and say, hey, that needs to be solved. No, a judge must wait until a case is brought. And it's important to stress that because the judicial process works within a framework of procedural rules which needs to be respected, because the legitimacy of a court depends on the court staying strictly within the confines of its jurisdictional task. And that task is laid down in the Constitution and the laws implementing it. For the European Union, it means the treaties on the European Union, that is the TEU, the TFEU, and the Charter of Fundamental Rights of the European Union. It is what the French would beautifully call le bloc constitutionnel. Le bloc constitutionnel is the primary law of the Union. So I thought, when the Dean invited me to take the floor in this series, how should I, as a lawyer, as a judge, and within the constraints I have just set out, contribute to the debate? And that is how I came to Article 2, that is the values on which the European Union is founded. I'll come to Article 4 in a minute, so this was only a small mistake. So the Article 2 sets out the values on which the European Union is founded. And these values, it needs to be stressed, start out with human dignity. That's the first value. Menschenwürde. Yeah, I speak English because that has been asked. I could also have done it in German, but I'm Flemish after all. No, Menschenwürde, la dignité humaine, de menselijke waardigheid, Nederlandisch. So in all the languages that comes first, followed by freedom, democracy, rule of law, and protection of human rights, as it is said there. And then something very important follows. In a society characterized by pluralism, tolerance, equality, in particular but not exclusively between women and men, protection of minorities, all sorts of minorities, that's a notion of social inclusion, and solidarity. When you add it all up, you come to 12 values. And an academic colleague once told me, in fact, this corresponds to the 12 stars on the European flag. I think it's totally accidental, actually, that these numbers correspond. But it's well found to say the 12 stars. And as you know, in the European Union, the European flag has always 12 stars, irrespective of the number of member states joining. So there is some idea of completeness in these 12 stars. Well, that's the values of Article 2. It's a complete foundation on which European states are ready to engage in a process of common governance. Because let's start there. What is the European Union? We think in this series about the future of Europe. But do we actually know, in an easily stated catchphrase, what the European Union is? Well, the Court of Justice said what the European Union is in a very short sentence. But it first started by saying what the European Union is not. The European Union is not a state. It's a simple sentence. European Union is not a state. That's a negative definition. That the court said in its opinion 2/13 of the 18th of December 2014 on the conditions of accession of the European Union to the ECHR, the European Convention on Human Rights. The court said the European Union is not a state, and therefore it had consequences on the conditions of accession. But with that, there is not yet a positive definition. The positive definition came in 2 full court judgments. And it needs to be stressed, full court judgments are very exceptional. That means all 27 judges sitting as a judicial bench. And that is when the court rules on constitutional law matters, which are so important that they have existential significance for the survival, for the sustainability of the European Union. These judgments concerned an action for annulment brought by Poland on the one hand and Hungary on the other hand against the European Parliament and the Council, asking the annulment of the so-called conditionality regulation. That is the regulation by which the European Parliament and the Council, acting in accordance with the ordinary legislative procedure, adopted a regulation spelling out the conditions under the angle of rule of law, but rule of law understood in the sort of intertwined triangle of democracy, rule of law, human rights. So the conditions which member states receiving subsidies from the European Union must satisfy in order to receive these subsidies. So it is conditionality regulation. And Poland and Hungary said, yes, but there is no competence for the Union to adopt this. Indeed, the European Parliament and the Council had based their regulation on Article 322 of the Treaty on the Functioning of the European Union. It's the article saying that the Union legislature may adopt financial measures, that is, legislative measures to protect the financial interests of the Union and the sound management of the Union budget. And the legislator had based its act on that provision because, as you know, the principle of conferral, the European Union can only legislate when there is a competence conferring provision in the treaties authorizing the Union to legislate. Das Prinzip der Einzelermächtigung, von Zuständigkeiten. So that principle needed to be complied with. And then the question was, is there a link between rule of law compliance and the sound management of the budget and the protection of the financial interests of the Union? And Hungary and Poland said, well, the rule of law, what is the rule of law? What is democracy? Those are aspirational texts which open a perspective, but everyone understands it a little bit in her or his own way. There is really no common understanding. It's an aspirational text, it's not a binding text in terms of obligations which flow from this provision. And then the court said, positively, what the European Union is. The court said, the European Union, not a state, but a common legal order, understood as a common governance structure. A structure of common governance for the participating member states. And this common legal order, the court said, is based on Article 2. That is the 12 values I have summarized. The 12 stars on the European flag. Member states which share these values in their domestic legal order and are intending to construct and to contribute to a common governance structure based on these same values, they participate in the foundational values that Article 2 says, that it are the values on which the Union is founded. Therefore, we say in an adjective, foundational values of the Union and the member states participating in the Union. So the court said the very identity of that common legal order lies in compliance with Article 2. So the institutions of the Union, they can implement these values, further develop these values, ensure the compliance with these values in their rules, in the rules they adopt, provided there is a legal basis. That's the principle of conferral. And in this case, the legal basis was Article 322 of the Treaty on the Functioning of the European Union. So there was a legal basis. The substance was to organize the upholding of the value of the rule of law. And in fact, this brings me to my democracy thing. Because this conditionality regulation, you should really, I say this here for all the young people in the room, you have it immediately when you go, you take our judgment, 16th of February 2022, on its date in the electronic court reports, and there you find the reference to the legislative text, and with a hyperlink you can click on it and you have it before you. And there you will see that what the legislator did was spell out 10 principles. So the value is rule of law. And then 10 principles fleshing out this value, such as, for instance, that equality of the citizens before the law must be ensured, that administration cannot act in an arbitrary manner, protection against Willkürlichkeit. It's essential for the rule of law. The fact that an adverse decision needs to be reasoned and that there should be the subject of judicial review. So all sorts of principles which for lawyers are self-evident, but which need to be spelled out. So a value, the value of compliance, of upholding the rule of law, rather general, is now concretized in principles. And then concrete rules to verify whether these principles are being complied with, and if not, a sanction. No subsidies are handed out. Values, principles, rules. Whom am I paraphrasing here? Values, principles, rules. Rommel Dworkin. It's Dworkin. It's a Dworkinian approach to concretizing these rules. And the court, without mentioning Dworkin, says this: values are by the legislator concretized in principles and rules, and the court is there to enforce them. So the scheme of this triangle, democracy, rule of law, human rights protection, within the member states and at EU level, is the sort of basis for the trust which the member states have to place into one another as equals to participate in this common governance structure and in the common legal order. And the common governance structure is not a goal in itself. It's a structure to reach or to achieve the policy goals which the member states in the treaties have designated as common goals. And you know them. The President referred to some of them. An open space without controls at the internal borders between the member states, the so-called Schengen zone. Yes, it's very beautiful. But if you have no longer controls at the internal borders, it inevitably means that you need a whole range of accompanying policies which are also conducted in common, such as a common asylum and immigration policy, at least to an important extent. The judicial cooperation in criminal matters, because the open borders are not only for a court of justice, judge or president coming over the border between Luxembourg and Germany to come to Trier and speak here on a Friday afternoon, but at the same time, it's not excluded that there is also a terrorist, a drug trafficker, or worse still, a human trafficker, crossing the same border to escape maybe criminal liability in the member state where he committed some offenses. And of course, member states want to be sure that they don't lose their jurisdiction to bring criminals to trial and have them subjected to their punishment, if need be, in order to uphold the societal peace. So the European arrest warrant, the judicial cooperation in criminal matters, the balancing of the rights of the accused vis-à-vis the rights of the victims of crime, and so on. So a whole range of legislative acts in the field of judicial cooperation in criminal matters, police cooperation like Europol, by which they can elucidate criminal offenses which have been conducted in the open space, and so on. So, I mean to say, the common objectives should be understood as objectives which member states can only efficiently and effectively, that is in order to reach the outcome and to reach the outcome in the most efficient way, can only really pursue in common. And the pursuance in common of these policy objectives is done through the common governance structure, the common legal order, as a vehicle for common governance. You know it, clean air. Dirty air does not stop at state borders. Clean water. Sustainable energy supply. What about the safety of nuclear plants? Prohibited in some member states. Yes, but allowed in the neighboring state. Yes, I know. Not in Germany. At least not for the moment, the nuclear plants. But when I see from my bedroom on the Kirchberg, I look out, I see the nuclear plant of Cattenom. Do you think I'm saying, "Oof, we're lucky, it stands in France"? Because from my bedroom, Luxembourg being small, you can almost see all the borders of the Grand Duchy of Luxembourg. But frankly speaking, if there is a problem with Cattenom, there's just as much a problem in Trier as in Luxembourg as anywhere else. So even for member states which have made a choice not to have nuclear energy, the safety of nuclear plants is an important common concern and need to be pursued in common. That's why there is the Euratom Treaty and its implementation. We can endlessly multiply the examples, the common currency, the internal market, but also social policy aspects. We have now a case pending before the court. I don't say anything about it because the case is pending, but it gives you the idea. A case where the European Parliament and the Council, under the ordinary legislative procedure, have adopted a directive on some aspects of minimum wage in the member states. But minimum wage is wage, and wages are excluded from the social policy measures. And the question is whether the content of the directive is not ultra vires. Case brought by Denmark, supported by Sweden. An action for annulment. So you see, it's a common governance structure which rests on the division of competence between the Union and the member states, and within the Union on a subtle institutional balance between the three political institutions, Commission, as initiative taker, the European Parliament, directly elected, and the Council, composed by national governments which are democratically responsible. And so that is why I thought, thinking about the future, of the European Union. And being aware of the fact that in this common legal order, this common governance structure, there are so many crucially important issues which are decided on the level of the Union, it's important that we reflect on the value of democracy. It's one of the core values of these 12 stars, these 12 values. And this not just at the level of the European Union itself, but also at the level of the member states, because the two levels are so strongly intertwined with one another that you can't really think about one without the other. And I'll give you a few indications, zooming in now more specifically on this value of democracy. Just like what I said for the rule of law and the conditionality regulation and the ensuing jurisprudence of the Court of Justice, concretized in principles and rules. Likewise, we have something similar going on in the context of the value of democracy. First of all, you should know that the value of democracy is in fact spelled out in the treaties in several provisions. So the treaties themselves contain more about democracy than in a way about the rule of law. The rule of law just figures once. Democracy figures on many more spots in the treaties. In Article 2 as one of the values, but then there is a full title, the Title 2 of the Treaty on the European Union, which speaks about the democratic principles on which the Union is founded. And I draw your attention to this Title 2, which spells out two understandings of democracy: representative democracy and participatory democracy. And I will focus here especially on the representative democracy, because that's the core essence, like in all our member states, of the input or impact of the principle of democracy, the value of democracy, in the actual functioning of the governance structures at the common level of the European Union and at the national level inside the member states. The treaty says that it runs over two tracks. The European Parliament, which is directly elected every 5 years. It's directly elected inside each of the states, participating states. There's not yet a European constituency, but all the same, it's direct representative democratic legitimacy. And then you have the Council, and here I read literally because it's crucial for the further analysis. The Council is legitimized through national governments, because the national governments have a minister in the Council, in all the different formations of the Council, depending on the subject matter on which the Council is acting. Then it goes on, national governments, which are themselves democratically accountable either to their national parliaments or to their citizens. So you see, the Council is also democratically legitimized over the democracy process inside the member states. The consequence is that the European Union cannot be fully democratic if democracy is not fully functioning in all of the member states. Democratic backsliding in a member state infects the Council, because the Council is itself dependent for its democratic legitimacy on the democratic processes in the member states. And then the question arises, what can the Court of Justice, if need be, do in that respect? And I'm only asking the question because I'm speaking here in an academic capacity, but of course, these cases might come to us. At the level of the European Union itself, we have plenty of judgments of the court since the Roquette-Frère judgment of 1980, upholding the role of the European Parliament in the decision-making process. And that's case law which you find in any textbook on EU constitutional law, including my own. So there you can read it. That's the easy part of the story. Many times told, so I will not do it over again, but it's crucially important case law. In the legislative procedure, the control by the Parliament of the executive process, the implication of the Parliament in the external relations decisions, etc. So that is well known. But the question is, what about democratic backsliding in the member states? Thereby threatening the democratic legitimacy of the Council of the European Union, which is one of the two chambers, if I may call it that way, of the legislature at the common governance level which the European Union is. Because member states, that's always a positive definition of what the Union is. Member states are not transferring their sovereignty to the European Union. You read that sometimes in scholarly writings. In my view, that is wrong. Member states are the bearers of sovereignty, nach wie vor. The only thing which they have decided, in accordance with their own constitutional requirements, is to exercise their own sovereignty in common, in accordance with ground rules of play laid down in the treaties. And one of the rules of play they agreed on is that the European Parliament, directly elected, and the Council, indirectly democratically legitimized, must be in agreement with the required majorities on exactly the same text. A bit like in the United States, the Senate and the House need to be in agreement on the same text to the comma precise. That's the same in the European Union. In America they call it the conference committee between the two. We say the conciliation committee between European Parliament and the Council. But the Council needs to be democratic. So what can the system do if there is democratic backsliding, not just rule of law backsliding, with lack of independence for judiciary and that sort of thing? There is extensive case law. I'm not going to talk on that today. But when there is democratic backsliding, what can the Union do? So, some have argued that if a member state were to, I say now, rig elections and not do anything against that, that member state would breach Article 10, paragraph 2, because it would no longer have a democratic representative of that state, that member state, in the Council, thereby endangering the functioning of the Council, and that would be a problem. It's only in scholarly writings. Fortunately, we did not have a case yet, and I hope it will not come that far. But what we have done, and that's what I'm now giving a few examples on, we have gone in the case law nevertheless, but through other channels, into a whole range of issues which are meant to strengthen democracy inside the member states. And there are quite a bit of handles, so to speak, in union law, which properly used allow to strengthen democracy at national level, because it's crucial for democracy at a common governance level. And it was bon ton, till 5 to 10 years ago, to speak about the democratic deficit of the European Union. Now, strangely enough, you don't hear so much about it. What people are concerned with is threats to democracy inside the member states, which are the constitutive, the component elements for the operation of the common governance structure altogether. So, The case law of the court has concentrated on a number of elements which are crucial for democracy. And I take the first one, transparency and accountability. The second one, I announce them first, is the freedom of the press and media pluralism. And of course, this is also work in progress, both at legislative level of the EU and probably at judicial level. What about social media, social platforms, which are organizing disinformation? What about big tech oligarchs? Yes, I do use the word oligarchs, big tech oligarchs, who come in to tell what people should do in their vote. If I'm well informed, I read the German press every day, so I think I'm well informed, but sufficiently well. That is also now a factor in the elections in this country, and not only in this country. Where are the limits? What is freedom of information? Is freedom of information with limits or not? Then the implication of civil society, and especially the fact that democracy relates to all people. During the Christmas break, I read a marvelous book. It's also available in German, on freedom, of Timothy Schneider. Über Freiheit, if you prefer to read it in German. It's very well translated in German. Where he explains that democracy needs the inclusion of all. If there are too big differences between too rich and very poor and societally excluded, what is then of the sustainability of a representative democracy model? If people feel totally neglected and are not sufficiently included. So let's run through this with the help of on hand of our case law, one by one. Democratic nature of the decision-making process. The court was faced several times with so-called transparency cases. And you may say at first sight, a transparency case, it's sort of a technical case on whether the conditions are fulfilled to get access to certain documents or not to get access, and it's administrative law, Verwaltungsrecht, it's sort of not so systemically relevant. Well, it is, and you will see why. I give you a first case. Access Info Europe is a non-governmental organization promoting transparency of government. And when I say government, I do not mean the executive an sich, as such. It's sort of the governance structure, the legislature, the executive, the whole political operation. And that's important, both at EU level, but especially at national level. In the member states of the Union, but also a few other European states with which the European Union has bilateral agreements, such as the EFTA states or the United Kingdom after Brexit, etc. And they asked access to the documents of the Council from which it should appear which member state had said what in the Council. So, the legislative process, you know how it works, the ordinary legislative procedure, for the lawyers in the room, Article 294 of the TFEU, which we called the co-decision previously. So there is a proposal from the Commission. It is being negotiated, that proposal, at the level of a working party, the working group, then the COREPER, and then at the level of the ministers. And when they have more or less a common standpoint, then they must enter into contact with the European Parliament, because, as I told you, the legislative text will in the end have to be approved by a qualified majority vote in the council, 65% of the population, 55% of the states, at least as minimum thresholds. That's a QMV. And in the parliament, it's a parliamentary vote calculated in accordance with the quorum, etc. It's all spelled out in the rules of procedure of the European Parliament. The council said to Access for Europe, I can give you the amendments which have been proposed on the Commission's proposal inside the workings of the Council, but not the identity of the member state which proposed or which opposed these amendments. I cannot give you insight in who did what. Access for Europe yelled and screamed and said, yes, but that's exactly what I need. And I hope you now understand already why. That's the practice in the field of what I just said in theory. The council is democratically legitimized over the national governments, accountable to their national parliaments or directly to their citizens for presidential systems where the president is elected by the people. And sometimes a mixture of both, which is also possible. But of course, for that democratic line in the national democratic structures to run fluently, you need to know what your own government has said. Did they oppose, propose, amend? What was their position? So that you can hold them accountable. Transparency, accountability. So at first instance, the General Court ruled in favor of Access for Europe, and the Court of Justice confirmed this by reference to Article 10, to the democratic principles, to the two layers of democratic governance in the common governance structure, and it was essential that there was democratic oversight in the member states, through their parliaments, through ONGs, through the citizens directly, on what the government is doing at European level. So that the government cannot come home and say, well, Brussels imposes us, as though Brussels were a Russian Tsar. It's not a Russian Tsar. They are co-actors in the process. That's how the common governance structure is meant to be. It's pooling the exercise of member state sovereignty, so they bear responsibility for that exercise. So the council lost and gave the names of the member states. Then the next stage came. You know, as I've told you, the council must then negotiate with the parliament. That's informally called the trilogue. It's the council, the parliament, and the commission. And they try to get to an informal agreement already in the first reading. You don't find that in the treaty. It's on the basis of an interinstitutional agreement between the Council, the Commission, and the Parliament that they try inside the first reading informally to come to an agreement so that at the formal adoption of the first reading text there is already this convergence and the text is adopted. Actually 80%, which is a good thing for the efficiency of the output legitimacy, the efficiency of the process, that they do it that way. But the negotiations in this trilogue, they were secret. So, De Capitani requested, it's a follow-up case to Access for Europe, requested from the European Parliament access to the documents of the trilogue. And in particular, again, who had proposed the different amendments, made a compromise text that is in fact the whole run of the negotiation. And this before it all came to a close, in order to be able to possibly influence and certainly to hold accountable afterwards. Here again, the General Court said that the Parliament was to give access in real time and any time thereafter to the documents of the trilogue, so that responsibilities can be allotted. It's a De Capitani case of, I'll give you the 22 March 2018. And the Parliament did not even appeal the case, because they had seen what happened in Access Info Europe. It was on the same line in a way. So it shows that transparency is enormously important for the accountability of the process at national level. So the European Union process should be a subject of discussion in the national politics, in the Bundestag, in the Volksting, in the federal parlement in Belgium, in de Tweede Kamer van de Staten-Generaal in the Netherlands. So it should be a subject of discussion. And by the way, those of you who study EU law, what is the first protocol annexed to the treaties on the European Union? It's not the protocol on subsidiarity and proportionality, although that protocol has also to see with democracy, because democracy requires that matters be dealt with as closely as possible to the citizen, yet in an effective and efficient way. But the first protocol is hardly spoken about. In my view, is much more important. It's a protocol stating that the Commission must send all its legislative proposals to the national parliaments, and well in advance, few months in advance, to the start of the deliberation process inside the legislature of the Union. Why is that? It's because the national parliaments must apply their mind to these proposals and give instructions to their governments. There should also be a debate in civil society. That is why these transparency accountability cases are so important, and they're fully in line with how primary law was meant to be. But of course, as we all know, members of the executive branches, government members, they find it sometimes very comfortable. It's of course slightly difficult to make these compromises, etc., to do that shielded off from the public eye. Yet, in the long run, it is not good, because the sustainability of the democratic legitimacy and support for a common governance structure can only exist auf Dauer when the people in the public feel concerned, feel that they have possibility through their different social actors to intervene, and it can be the social partners, it can be consumer organizations, environmental organizations, business organizations, any organizations, that they can have their input through the existing channels in the process. Now, transparency can sometimes have limits when there are, for instance, personal data to be protected, and then you have to make a balancing of rights. But here again, the task to balance the rights is a democratic task. We all know Article 52, first paragraph of the Charter, saying that the limitation of the exercise of a fundamental right, included in the Charter, needs to be provided by law. Why by law? It's democracy. The fine-tuning of the balancing between opposing fundamental rights, in my example, transparency vis-à-vis personal data protection, is a democratic choice incumbent upon the legislator. And the judge will only step in when there is a manifest error of assessment. So that, I think, is a very important first step for the transparency. Accountability. I say one footnote about the fight against corruption and fraud. And you may be astonished that I'm saying this here in a speech about the value of democracy. But let's face it, how is democracy oftentimes undermined? It's undermined because governments are not respecting the applicable rules in public contracting. Vergaberecht. They give the contracts to their friends, and it becomes even worse when it's contracts financed largely by EU funds. When they're handed out to the friends of the ruling party and the friends of the ruling party, who then with the windfall profits they have so realized by the media outlets or the social media outlets, recently bought by a person very often now in the media. I will not be more specific, you see what I mean. Then in fact, the public funds serve to undermine democracy, media pluralism, etc. The Agora idea of a basic framework within which, like Jürgen Habermas has written, deliberative democracy can thrive. So that is why the Court of Justice of the European Union, but it would lead me too far, has a very, very strict and stringent case law on combating fraud and corruption with EU funds. So we had a whole range of Romanian cases, Hungarian cases, and others which are pending. So the idea is, that's also this conditionality regulation principles. It's rule of law, but in a democratic society and on the respect of human rights. Member states cannot use union money in a way incompatible with the objectives for which that money has been handed out. And if something goes wrong, there should be effective judicial sanctioning mechanisms and recuperation of the funds illegally handed out. And that is a crucial element in order to have democracy work in an even-handed way with equality of chances and opportunities before the law. The second point, free press and media pluralism. The Court of Justice has in its case law always protected and enhanced media freedom, the freedom of the press. And the freedom of the press, it's not only the institutionalized press. There is also so-called citizens' journalism, that people take now with the iPhones, the photographs, and they post things on the social media. It's all to be seen as a freedom of expression, and in a very larger sense, also the freedom of journalism, and indirectly of the press in a substantive way. So the court said already in 2008, in the Satakunan case, that the processing of data for journalistic purposes applies not only to media undertakings, but also to every person engaged in journalism as an activity. So we had several cases where the individual citizen was protected because of the exercise of journalism activities, although it was a private person. But spreading ideas, accompanied with pictures taken on the spot. We had one case which I find very, very telling, is the Buivits case. It's somewhat difficult to pronounce. 2019, it was a Latvian case. I've been sitting in the case, and there it was a person who was interrogated by the police in a police station. And he found that he was not treated well So he had filmed, in fact, the whole thing with his iPhone. Then he had blackened the faces, or sort of made them hazier, the faces of the police people, but you could still see their behavior. And he had posted that on the social media. So the Latvian police authorities came up against that and said, no, you can't do that. And he said, yes, but I'm a citizen journalist. Court of Justice ruled in his favor. It was under personal data protection. That was because we always have to have, of course, a connecting factor, a nexus to substantive union law. So the person won. So that's very important. And what to think about our very recent judgment that you must probably read, I think, for the youngsters here in the room. That is the Real Madrid case. Who did read the judgment? 4th of October 2024, Grand Chamber judgment. Real Madrid, the well-known football club. Well, there was a journalist of Le Monde, the leading French newspaper. And the journalist had explained that there was suspicion that the players, and in particular a few players of Real Madrid, had engaged in doping, and that they were assisted by the same doctor who was sort of the name always occurring in the sports of cycling, the cycling sports. And he had made a link there, the journalist, and published an article. So Real Madrid says, well, we have suffered damage in our reputation, and our players as well. But Real Madrid, as a club, also on behalf of the players, brings the case in a Spanish court. And here you need to know a little bit of private international law, internationales privaatrecht. That's also a subject of union law, of course, to know which is the competent court, what is the applicable law, and under which conditions is there recognition and exequatur of judgments in civil matters, in this case a tort case, in another member state. You know the subject. So, they say, well, the damage is being suffered in Spain. Under Brussels I regulation, there is international jurisdiction of the forum where the damage is suffered. That's Article 7 of the Brussels I regulation. So the Spanish court is competent. The case goes, the torts case, first instance appeal, Tribunal Supremo in Madrid, at all levels. The journalist and Le Monde lose. It's not true, it's defamation, and they're convicted. The conviction amounts, with interests and costs of proceedings, to 500,000 euros for Le Monde and 50,000 euros for the individual journalist. But of course, they have their patrimonium, vermögen, in France. So there is an exequatur procedure in France, because forced execution of that judgment. And the French courts say a conviction to damages in such an amount for a journalist, this is against freedom of expression, freedom of the press. It goes way too far. This is against ordre public, public order in France. The case goes in France as well, all the way up to the Cour de Cassation. It's the highest court. And they ask the Court of Justice, reference for a preliminary ruling, whether the ordre public exception, which is provided for in the Brussels I regulation, can be fleshed out with the protection of the freedom of the press and the fact that the journalist has the right to make an error, because you can't really be free in expressing your views without the right to err in good faith. And of course to be contradicted then by other journalists and by other authorities. That's quite clear. That's the marketplace of ideas. Theses, antitheses, etc. Right? So so the Court of Justice indicated, and it's crucially important, that the amount of the damage may not have a chilling effect on the exercise of journalistic activities in the member state of execution. And if there is, given the amount, the extreme amount of these convictions, the risk of such a chilling effect, which is as a matter of fact to be assessed by the referring court, in this case the French courts, then there should be a reduction of the enforcement. It's a bit technical. That does not mean that the Spanish judgment is being changed. It remains in Spain, the height of conviction which is there, and if ever they have assets in Spain, they can still be seized. But in France, the assets can only be seized to an amount, a lesser amount than the conviction of Spain, a proportionate amount, and the court refers to the principle of proportionality, which it applies like in Germany, Verhältnismäßigkeitsprinzip. Geeignet, erforderlich, angemessen, ja? Die 3 Schritten. So that's what we apply, and so they could indeed reduce it. So you see, the freedom of the press is something in the member states which is protected by the court. It's very important to do that. And then a first sign that the court is also sensitive to abuses of the freedom of the press, which lead to indoctrination, hate speech, call for war, the setting up of peoples against one another. And that's, of course, the case law of the General Court again, Russia Today, France against Council, where the court said that media pluralism is to be protected, but when a press channel is used as a propaganda channel to spread hatred, war, genocidal calls, then the member states should limit. It is the saying well known, tolerance should always prevail, but we should be intolerant for intolerance. And that's a bit the idea here. So that's an important point. RT France against Council. RT France lost the case. That was, the case where RT France was put on the list, the sanction list, after the invasion by Russia of Ukraine. And they came before the General Court and said it should be annulled because it limits our freedom of the press. And the court says, yes, at first sight that is so, but the limitation of this freedom can be justified under Article 52, first paragraph of the Charter, when there is an overwhelmingly important objective and it is proportionately pursued. And that's exactly what the court held here. It said that the content of the channel was propaganda for the Kremlin standpoint, justifying the invasion, that this was advocating war and hatred between the people, spelling out that the Ukrainian people is not a people and that they should be vernichted, annihilated, and therefore the court said that goes so far that the very fundamental values, they even refer to that first value, menschenwürde, should be protected. So that prevailed. But you see, all of this plays out in a way at national level, and the court supports the member states' legal orders in remaining pluralistic, in remaining based on the deliberative context, which is a deepening of democracy at that level. But it has the limits which I indicated. But that's, of course, a very extreme case. I shall be very short now because the third point is the implication of civil society. I have already referred to it when I spoke about these ONGs and no, that's French, the NGOs in English, the non-governmental organizations, Organisation non gouvernementale. French is the working language of the court. It's not my language, but I mean, it's the language of the court. So that's why we sometimes have, and those are interesting points. We have had cases about the social partners, for instance, concluding an agreement between them, management and labor. It's provided for in the treaties that the social protection legislation can be negotiated by the social partners at EU level. And then the question is the political process obliged to make such agreements binding? And there the court has said, well, they're not obliged, they can do it, but they have a margin of their own assessment. Because for important the social agreements are, they may have to be balanced off against other interests, and that needs to be done through the channels of the normal representative democracy. The same applies for the citizens initiative, you know, the 1 million signatures for inducing legislative initiatives. There as well, I refer to the Pooping case of 2019. The court said there as well, it's of course an important impetus. The Commission, if it does not take up a legislative proposal after such a successful initiative, the Commission must explain it, it must justify it. That explanation can be attacked in court, it's admissible because it closes the procedure. It's an acte faisant grief, so you can attack it. But the Commission must have the prerogative of making the balancing. Even 1 million of signatures comes within 450 million people, so other interests may have to be taken into account. So there again, it's always the concern to have a specific interest group taking the lead, but thereafter democracy as a whole must come into play, because of course at the level of the common governance structure, where these 27 member states exercise their own sovereignty in common, many interests have to be balanced off against each other. So it's not so one-sided and one-focused, then even an agreement between the social partners or a citizenship initiative can bring to bear. We had, of course, cases protecting civil society inside the member states. You know our Grand Chamber Judgment Commission against Hungary, where they were blacklisting all the NGOs receiving funds from sources in other member states and more or less characterizing them as inimical funding partners, that is sort of to be distrusted. So it was stigmatizing Hungarian NGOs getting money from Germany or from France, etc., as though it were coming from the enemy. Whereas, of course, in the European Union, in a common governance structure, also the democratic debate must be able to be conducted at a level including the whole territory of that common structure. And indeed, it does matter also for German interests, for Belgian interests, for Danish interests, how, for instance, the environment is protected in Hungary. Because looking at the map, we're all in the same boat, aren't we? That's why it was conferred on the Union in the first place. So those seem details, but the court in fact emphasized, with a view to the democratic principles on which the Union is based, that there be a lively democratic debate inside the member states, conducted through NGOs, but also across state lines with connected NGOs and funding partners all over the European Union. So that's a very important judgment of 2020. And another was, of course, on the Central European University. Also, universities play a crucial role in consolidating democracy at national level, and it also should be able to remain open to inputs from all over the place. And that should be part of academic freedom, and it should not be steered by the government as such. So all these cases had sufficient connecting factors to substantive union law to give the Court of Justice the right to rule on them. A last element, I'm almost done, is the inclusive character of democracy. You know, the Court of Justice has an extensive case law on protection of minorities, all minorities. You know our case law of non-discrimination on the basis of race, ethnic origin, gender, sexual orientation, handicap. All these cases based on the directives 2000/43 and 2000/78, but also sometimes directly on Article 21 of the Charter, the non-discrimination principle applied in all the fields of activity of the European Union, they aim at inclusion. Democracy is not the rule of 50+1. Also, the minority is just as much part of the democratic ensemble, which is governed by, of course, a vote. The minority will have to accept the vote after a fair interaction between all the stakeholders concerned and all the representatives of the people concerned, that's for sure, but no one can be excluded ex ante, not from the employment market, not from the services market, not from the goods market, because people who get marginalized are a threat for democracy as we know it. People who get alienated from the system in which we live, they turn against the system, they are easily manipulable by social media, by the giants of the social media, who, through data mining, find what people would like to read in their social platform accounts, and they're being confirmed in a sort of closed tunnel vision that can never lead through deliberative democracy like Jürgen Habermas has so well defined it. And so that is why when the Court of Justice rules on these discrimination cases, it is ruling on democracy inside the member states and at the level of the European Union. So you heard me say it. The European Union is not a state. It's a common governance structure to reach common objectives which member states and no one else, as Herren der Verträge, have conferred as competences on the Union in order to exercise parts of their own sovereignty, which remains their own sovereignty, in common. I say which remains their own sovereignty because a member state can withdraw from the Union. It's Article 50. So they exercise this in common, but on the basis of fundamental rules, constitutional rules in a substantive sense of the word constitutional, ground rules of play, of functioning of that common governance structure. And the key value on which that structure must rest is democracy. But first and foremost at national level. And then it sort of trickles through at a common level. That's the principles of the democratic principles on which the Union is based, of the Treaty on the European Union, the Council, the Parliament, transparency and accountability, freedom of the press, marketplace of idea, thesis, counter-thesis, synthesis, and inclusiveness. All citizens count, also minorities, social inclusion, and some equality in social well-being, in wealth. Some equalization is a necessary condition. When the top 1% becomes always richer, and the 50 lowest percent always poorer proportionately, democracy as we know it has a huge problem. And we see indeed in the three empires in the world, the Chinese, the Russian and the American, the top 1% is in the power, also politically. The 50% of the lowest class, I mean the 50% of the whole population, which has not even 20% of the wealth, feels largely excluded. That is a very explosive future for democracy. So future of Europe goes hand in hand with the future of democracy as a system of governance, first and foremost in the member states, social justice, social inclusion, transparency, accountability, access of all to the decision-making mechanisms, and input through various channels, people feeling involved and concerned. That is democracy. And democracy is in fact another word for the future of Europe as a self-standing model. Self-standing, different from the US model, different from the Russian model, of course, different from the Chinese model. To only take those ones. That is the identity of the European Union as the Court of Justice defined it in the conditionality judgments. That's the values of Article 2, with at their center the democratic value, the 12 stars of the European flag. Thank you very much.